Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. Psychedelics and end-of-life care, understanding the legal landscape. Wow, this is an exciting topic. And so Karen, Natasha, Kimberly, thank you so much for joining me, and you're the leads on our psychedelic practice here at the firm. So it's a real honor to have you. And this is such a cutting edge area I know nothing about. So I'm just here to ask inquisitive questions that hopefully our listeners want to hear the answers to as well, because I know I'm dying to learn more about this area. So given that many of our listeners probably don't even know what psychedelics, from a legal standpoint, what it is and what it isn't. And so can you, Kimberly, talk a little bit about what psychedelics are, like what fits in that bucket, and who defines what is a psychedelic for drug purposes?
Yeah, thanks so much, Meg. Certainly, first of all, I want to thank you for having us on your podcast. So psychedelics is really a loose term for substances that have psychoactive properties. It doesn't really have a legal term per se, other than legally, a lot of the psychedelics, in which case we're talking about things like MDMA, LSD, psilocybin, DMT, ayahuasca, ibogaine, are on the Schedule 1. And there's one substance that is that is considered a psychedelic. We kind of group it under this terminology because it does have psychoactive properties, but it's a different schedule under the Controlled Substances Act, and that is ketamine. So ketamine is a Schedule 3. It was approved by the FDA for use as an anesthetic, and it has been gaining popularity for off-label use for the treatment of anxiety and depression. It's really just a loose term. So basically, if a psychedelic substance is part of the Schedule 1 under the Federal Controlled Substances Act, then it's basically found to not have any approved medical use, considered to be highly addictive, and to have a safety profile issue, generally speaking.
Well, and you're a scientist, so I'm taking your word for that.
I was.
So you dumped that down for us. So thank you for doing that. A scientist and a lawyer, so super smart. So Natasha, so most of these substances then are not approved for any medical reason, but there's all of these trials. I think you can't, read in the newspaper. I mean, it's becoming commonplace in public media. I know as we're recording this session, the New York Times just had an article on the use of psychedelics and end-of-life care. And so I think it's in popular media. So we have you hear about these federal trials going on, and then we say, oh, Oregon allows certain clinics in Colorado. And so it seems like there's federal and state issues, and there's these trials. Tell us a little bit more about what's going on in terms of trials, and how does that work if these substances aren't approved medically and they're illegal substances?
It is confusing, Megan, and it's confusing to a lot of people. And I think it's confusing, especially because there's so much out there in the media. That's exactly right. It's kind of, people use the term, there's a renaissance going on, with psychedelics right now. So as Kim said, almost all of these drugs are on, Schedule 1, which means that there is no, medically approved use. So the only way that anyone can, quote, use these drugs are in clinical trials. So, and there are very specific ways that anybody who is a researcher can legally, get these drugs. So you have to go through, and get DEA licenses and all these things. It's a pretty, complicated and long process to do that. And so, yes, there are lots of trials going on. Many people are familiar with MDMA and the new drug application that unfortunately was not approved by the FDA fairly recently. So that will continue on, and there'll probably be some more phase 3 trials going on. And then, that will be another new drug application that will then, be hopefully approved at some point, and MDMA will then hopefully be approved at some point. Psilocybin trials are going on, LSD. Yeah.
And maybe if I can pause you there for a second. So the
Sure.
trials are essentially to test the medical efficacy of these drugs to do something which you need to then file a drug application with the FDA to say, this can legally be used and prescribed by providers to treat various medical symptoms, which, in end of life care, there's just a lot of existential angst around that. And so that's what the sort of nuts and bolts of these trials are. Got it.
That is exactly right. That's exactly right. So what, most of these are studying one very particular use. So use for anxiety or use for post-traumatic stress disorder. So this just isn't just kind of a general, like, throw it on against the wall and hope it sticks kind of idea. And this isn't, okay, so we're going to, study this drug and then suddenly MDMA is going to be moved from Schedule 1 to Schedule 4. That's not what's most likely going to happen. Okay, so you asked the question, state and federal. So at the federal level, it is illegal, except for research. So we also have, as you mentioned, Oregon. So Oregon has this program, this state program. Now, just for your listeners, I am not an Oregon, lawyer, and so, but Oregon does have this program that's approved. It's a state-run program, and basically, there's psilocybin approved facilitators that can run these psilocybin that can facilitate psilocybin sessions for PTSD, anxiety, whatever it is. Okay, so that's at the state level. And then Colorado also has some program, and I don't know all of the details and specifics of that. The sort of rub is that, this is, they call it like federalism, but basically federal law in anything really trumps state law. So federally, all of this is illegal except for for research, but you have at the state level, you have the state-run program, especially in Oregon. And so it's sort of like, well, is this legal and what's going to happen? And quite frankly, nobody knows. But it's very confusing to a lot of people. And so we get a lot of questions, people will call us and say, hey, I want to, open up this psilocybin, microdosing, blah, blah, blah. And we have to explain to them, well, it's not legal. It's not legal even in, Oregon or, other than at the state-run program or whatever. And it is very confusing to folks. And so we do a lot of explaining of the difference between, federal and state and how that works. And it is disappointing to people, I know. But hopefully we do a good job of explaining that.
Yeah. Well, and it sounds like because I think we were probably the first law firm in the country to have this psychedelics practice group. So is a lot of what you all do in the practice group about helping people with clinical trials related to these? I know, Karen, you're going to tell us a little bit about the litigation we were involved in, but is that, since it's not currently legal, is that mostly what the legal work is that there is to do during this period of time?
Yeah, that's exactly right. So clinical research work. And then, as Kim mentioned, there is also ketamine. So because ketamine is a Schedule 3 drug, it can be used legally off-label. And so we have assisted quite a few folks, with setting up ketamine clinics, helping them with their sort of corporate piece, and then understanding, how to get the clinic itself up and running, the brick and mortar, and that sort of thing. So we've done that quite often, and many of these folks are wanting to get the ketamine clinic up and running with the hope that, MDMA, psilocybin will be legal at some point, and they will already have everything kind of set up, and they can then just move into the next phase. So,
yeah. One more question before we get to litigation with Karen is like, just throwing this at you. So the road to the legalization of marijuana, is there anything that can be learned through sort of that trajectory there? I mean, I think we're talking about very different substances that probably have different concerns related to them, but like, what do we learn? Because we also were one of the first law firms in the country to have a, uh, you know, medical marijuana practice. And so, what do we have given all of our deep knowledge in that area? Is any of that helpful to say, how long is this going to take? What's going to be required? Like, any insight from that?
Yeah, I mean, I think Karen actually is probably a better person to answer that because she actually did practice some cannabis law, and I'm not a cannabis person, but I will say that they are very different practices because cannabis really did go more of kind of the business sort of end of things and really didn't go on the medical side. There was not a lot of research that happened,
Okay.
and so the research is really happening now. And so it is very different. And people ask that question all the time, which it does make sense, right? Are they, they're both Schedule 1. There are medicinal, properties for both cannabis as well as all of these other Schedule 1, not all of, but many of these Schedule 1 drugs. So it makes sense, but they are very different. I think the trajectory that we see for these drugs that we're talking about, is, I don't know if MDMA is going to be first. I think it just depends on what happens with the sort of psilocybin that's up next, because psilocybin, there are drugs, psilocybin that are in that are in phase 3 trials. So if there's a new drug application that gets filed with the FDA coming up fairly soon, that may happen before the sort of phase 3B, 3C, whatever's next for the MDMA. If those don't complete, then I think we might see psilocybin next. But I think it's going to be MDMA, psilocybin. Those are going to be kind of what's next. And I anticipate that in the next couple of years. But I don't know that anybody real other than the folks that are doing the research really know kind of what, but that's what I think we're going to see. Cannabis is a little bit different, but I think Karen might be able to talk a little bit about that.
Yeah.
Karen, what are your thoughts on that?
Well, this is it. I think one, it's a sort of different perspective on this is cannabis, I think, is a really good example along with psilocybin about how the current regulations or the FDA or the Controlled Substances Act ignores the fact that there are many Schedule 1 substances that are currently in Schedule 1 that have accepted medical use, because medical marijuana has been an accepted thing for, decades now, right?
Yeah.
But it's sort of still in Schedule 1. Well, under the Controlled Substances Act, the definition of a Schedule 1 substance is that there is no accepted medical use. So
interesting.
I mean, one of the definitions, but it's pretty much the main definition of, is that there is absolutely no medical use, and that's why this is Schedule 1. Marijuana clearly nobody thinks marijuana fits into that category. Yeah. It's still in Schedule 1, so it's sort of a disconnect here. And that's actually, we're going to move and talk about litigation next, and that's exactly what the series of cases that the firm has been helping out on is about. And there's a really interesting series of cases. They're called Ames versus DEA, and they are in the Ninth Circuit Court of Appeals. And there are 3 of them.
So that's in California, right, Karen? Okay.
Well, Ninth Circuit is California and Arizona, and then I should probably know all the states that are in there, but it's it's several states, and each of these cases are called Ames versus DEA, so it's a little confusing. And then people who are we who work on these cases refer to them as 1, 2, and 3. But basically, I want to talk about 2 kind of aspects of it. Like one aspect of the one Ames case was a direct petition, and this is very similar to how cannabis is a Schedule 1 drug, right? One of the Ames versus DEA cases was a direct petition by the petitioner to reschedule psilocybin from Schedule 1 to Schedule 2, based on the argument that there is accepted medical use. So So a little background on this, Dr. Sunil Agrawal, who is the head doctor in the AIMS Institute. AIMS stands for Advanced Integrated Medical Science Institute, and it's a Seattle medical research organization. And Dr. Sunil Agrawal is a doctor who practices in Seattle, and he's a palliative care doctor who wanted to provide psilocybin therapy to his end-of-life patients. But he didn't want to risk losing his medical license for unapproved use of the Schedule 1 substance. So what Dr. Agarwal did was he wrote the DEA and asked, hey, can you accommodate the use of psilocybin under the Right to Try Act? I'll talk about that in just a second. But the DEA refused, and they sued. And so AIMS Institute sued the DEA, and they argued that the DEA sort of improperly, summarily denied their request to reschedule psilocybin, even though there is definitely accepted medical use for psilocybin. It has been granted breakthrough therapy status. There are definitely there are clinical trials going on, and they quoted scientific articles about this. But I think backing it up to the more sort of practical aspect of what like non-scientists would find interesting about this is that the use of psilocybin for end of life care. The point of it is like right now, I think in hospice care and a lot of end of life patients, there isn't a lot that we do for these patients other than give them painkillers. Psilocybin therapy has been proven to directly and profoundly help end-of-life patients deal with their impending death on an existential matter, like existential level, and really just come to peace with that. And that is, arguably just as important as making them physically comfortable. It helps them be at peace with the fact that they're going to be passing. So it's a sort of different focus on palliative care and a sort of shift towards, maybe we should recognize that this is also an important thing for people who are dying, not just to, mitigate their pain, but to help them, ease their transition.
Well, and what you're saying makes so much sense, Karen, when you think about the structure of the Medicare hospice benefit. I mean, it's dealing with the different quadrants of your being. I mean, it's like, okay, we have a physician and a nurse dealing with your medical symptoms, but then we have a social worker that's helping you with the psychosocial issues. Then we have a chaplain who's part of your care team that is helping with, the spiritual aspects, because dying is not a medical event. It is a like whole body event. And so I think what you're saying really resonates a lot with, there's a lot more than just the physical symptoms of dying that we need to palliate, I guess. So anyway, it's very interesting. So this case that I understand our firm, and you in particular did this amicus brief, so friend of the court brief, in one of these AIMS cases then?
Yes. So we represented a cohort of almost 30 doctors and some of the most prominent names in this field who urged the DEA to reopen, or actually to open a rulemaking proceeding so they could be heard on their experience with end-of-life patients. Because what the DEA did was they summarily denied the petition to reschedule psilocybin. And our amicus brief was on behalf of the doctors who said, hey, you should listen to us. I mean, why these doctors directly deal with end-of-life patients, and their voice should be heard because there is an accepted medical use. And who is making the determination of whether there is an accepted medical use? Maybe you should talk to the doctors and have them make the determination and not the DEA, who is, the enforcer. That's what our amicus brief was about. And psilocybin is twice been designated a breakthrough therapy by the FDA. It clearly has medical use and doesn't belong in Schedule 1. So that was AIMS. That was one of the AIMS cases. Oral arguments happened over a year ago, and the court actually granted the petition and ordered the DEA basically to, come back and explain themselves. And unfortunately, they remanded it back to the DEA. So it was like sort of, and then ordered the DEA, you need to give a better explanation. I mean, it's well over a year. It's been, I think, a year and 2 months now. The DEA has done absolutely nothing. They're completely dragging their feet on this. So hopefully something does happen soon. The DA actually listens to the court's order and explains themselves about why they summarily denied this rescheduling. But that's not the only strategy that Ames is taking here. And there was another Ames case, which is a petition to allow psilocybin under the Right to Try Act. And so I think it's 31 states, might be more now, and the federal government have enacted right to try statutes. And the federal Right to Try Act was enacted in 2018, and it allows patients with life-threatening conditions to access experimental treatments that had not yet been approved by the FDA. And all the proponents argue that psilocybin should be available under this framework, given its potential therapeutic benefits. So that is a sort of different tact to it, and not it's a different argument than basically psilocybin doesn't even fit into Schedule 1. But this argument is psilocybin should be allowed under Right to Try. And in order to be allowed under Right to Try, it has to be an eligible investigational drug. So would have passed phase 1 clinical trials for safety. I think there are 2 psilocybin drugs right now that are past phase 1 clinical trials.
Oh, really? Okay.
There are drug candidates. So this therapy is available. And the argument is that the DEA should allow it. There's no reason why it shouldn't be allowed under Right to Try. These are needy patients who are at the end of their life and don't have time to wait around for FDA approval. They might pass away by the time that happens. Oral arguments happened on that several months ago. We went up to San Francisco and listened to them, and there's not been a determination by the court yet, so we're gonna have to watch for that.
Interesting.
Yeah, and it is going to have a lot of far-ranging implications. It's the outcome of Ames versus DEA could set legal precedent about on psilocybin and other psychedelics. It'll affect medical research and access, and it could change the regulatory framework. So there's a lot of interesting stuff in the works, and we're really keeping an eye on this.
Yeah, it's like truly trailblazing. I mean, this is an incredible work you guys are involved in. Very exciting times. So I guess maybe we bring it, and there's clearly like a part 2, part 3, part 4, like ... to this podcast. But I guess for today's episode, maybe we conclude with you, Kimberly, talking about, because I know you talked with clinicians before about what are your legal and liability considerations as it relates to these issues. Because if you're doing end-of-life care, palliative care, or working with patients that might benefit, and people are like, can I do this? What are my risks to my license and personally? Like, what are some sort of high-level issues that you go through with people on that?
Yeah, sure. We actually do counsel a number of clinicians that worry about how to protect themselves from malpractice claims when discussing, psychedelic therapeutics. And I'm just going to back up a little bit because that just, if you're just going to wonder, where is the risk, the legal risk, it extends back to the Controlled Substances Act and accomplice liability that attaches. So basically, accomplice liability is kind of any activity that's deemed to, like, quote, aid and abet the furtherance of these prohibited activities under the Controlled Substances Act. So, lots of physicians or prescribers may be worried about referral to a psychedelic treatment outside of a research context, or even referral to research. How is that done? And would liability attach? That sort of thing. So, I mean, in the United States, I'm just going to focus on ketamine because on a federal level, where I'm going to just kind of leave Oregon and Colorado out of this conversation for now, that really we're kind of only really talking about ketamine as a psychedelic treatment. So a physician or prescriber may be thinking, well, what are the risks involved with kind of recommending or discussing with my patient a ketamine as a therapy, like low dose ketamine as a therapy for the treatment of anxiety or depression, which would be off-label use. Off-label use, as many physicians and practitioners know, is kind of practice all the time with all kinds of drugs. And so in that case, we would basically, like what we like to say is like, yeah, off-label use is legal, and that's on a state that you have to go into your state and more local guidance as to your practice and the best way to manage your practice. But the promotion of off-label use is really not legal. So if you're promoting that this is, you should use as a first line of treatment for anxiety, you're recommending the off-label use of ketamine. We don't recommend that as the best practice. There are other therapies available for treatment of anxiety and depression that is probably best practice to follow through first before resorting to off-label use of a substance like ketamine. I know that might drop some controversy, but that really is just the safest practice to your practice. The safest way to practice this. And then we also recommend that clinicians provide medical monitoring. And not everyone, because ketamine's off-label, there's kind of across the gamut kind of use that we've seen. All the way from at-home use to, or which with trocars or pills or something like that, or going into a clinic for an injection, intramuscular injection, or going to a clinic for an intravenous IV, a slower infusion of ketamine. For clinicians, we recommend that they provide medical monitoring and advise that they stay under the care of a qualified primary care or physician or mental health provider as they're undergoing a ketamine treatment. The typically what we've been hearing from practitioners is that this is not it's not a one and done. So it's different than a lot of other psychedelics. The psilocybin has been said to have life-changing events, even with sometimes a single treatment.
I read that too.
Yeah. But ketamine is not known to have these kind of durable effects. It's more of something. It's not worked out since it's off-label, but I mean more frequent, like monthly, etc. That sort of thing. And then you have to undergo it a couple of times at least. And so some people do not respond. I mean, there's some I've heard from researchers that sometimes people don't respond until 12 sessions later, which seems really long. But some people respond right away, so we kind of run the whole gamut. And so we do recommend, just good communication with their patients that include a statement that, this is not recommended by the FDA. Per se, it's not approved by the FDA. It's approved for as anesthetic, but low dose is not approved by the FDA. So it would be good to disclose that as part of your practice, in addition to other informed consent things that you should be disclosing as well. So if a clinician is thinking about referring to like a psychedelic clinical trial, some of the things we advise them to do is to, when discussing with our patient about this possibility, is to explain to them that clinical trial, because not everyone understands. I mean, that it's experimental in nature, and that there is control group participation, and that there will be inclusion criteria associated with the clinical trial, in which case they may not qualify for such inclusion and therefore may not be part of the treatment. So there's just no guarantee of a treatment, and that they will be signing informed consent before participation. It will have its own medical risks associated with that clinical trial. And that's just something that, even though the clinical trial is legal, if it's all done legally, if a physician is referring out that's just something to mention, right, as a best practice to their patients, that is just, that there's discomfort, there's no guarantee. Other considerations that a physician should consider are things like, the physician-patient privilege, which, I'm sure lots of physicians are aware of this, but it just protects, that privilege will protect confidentiality of communications between the doctor and the caregiver and the patient, but that does not exist under federal law. So that's something, that's just something that we like to, point out for when they're talking about a substance that's currently on the Schedule 1. It's illegal, and if you just don't want any accomplice liability to attach to your practice, it's best to be aware of all of these risks that, these things that they're talking about, unless it's part of a clinical trial in the United States, and they're U.S. physician that they're better off sticking, and not having a complex liability attached from the Controlled Substances Act, sticking with all the legal avenues, which is research or ketamine at this point.
Yeah.
So yeah, it's generally unlawful to talk about illegal substances, but they can under certain frameworks.
Ugh. This is hard stuff, man. Well, this is why I'm so glad that you're here and can answer these questions, because I think a lot of people are very curious about this. And obviously, most of our listeners are all end-of-life and palliative care providers. So I think, first in line of who this could, patients could be, benefit from this. But also, as this is in the public media, I think being very aware as a hospice physician, what you are talking about. I mean, we've dealt with this a little bit about, cannabis, and because that's still illegal from a federal perspective. And so Medicare dollars can't be used to pay for that. And, some of these issues, but are somewhat familiar to hospices. But so it's just, I think, wonderful to have you all as a resource as people navigate this, because this feels like it's prone with a lot of challenges, but it's also a really exciting time. And as someone who, is at a dead end in terms of how can they help their patients, there's a reason why it's being studied in how many clinical trials right now, that there's hopefully a lot of potential for helping people here. But well, this is fascinating. Thank you so much, the three of you, for your time today. This is wonderful. And I just know that we're going to be talking again. So I have people that are waiting to listen to this podcast. I have someone, you said you're doing the Psychedelics podcast. I don't see it coming out. So we have people that are just waiting every time we release our podcast. So we're going to be releasing this. We're recording this here at the end of 2024, but it's going to be, I think, released here in the early part of 2025. And hopefully the law hasn't changed dramatically, but I'm going to bet that it hasn't by 2025, right? By January 2025, with everything we said is still going to be relevant, because we know government moves very, very slowly. So
I don't know. The one thing, Meg, we might see, though, is with Kennedy coming in the new administration, and he's pretty pro-psychedelic. So we may see some pretty quick changes, but not by January 2025, but fairly soon after. We might see some, which is a good thing, because this is the kind of thing that we do want to see for your listeners and the physicians and their clients, for sure.
Yeah. Well, wonderful. Thank you so much for your time. And I can't wait to hear how all of this develops. So thanks again, and we'll talk soon.
Thank you.
Yeah, thanks so much, Meg.
Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.